Welcome back, everybody, to DissedMedia, a startup story, the podcast where we take you behind the scenes of starting a business from the ground up. You know, one of the things that entrepreneurs, business owners, people who have a creative mind, a lot of times we like to come up with things. We like to invent. We like to create. And often what usually follows that is the question of how do I protect this, right? How do I make sure that this thing that I have created, whether it's a creative work, whether it's a logo, whether it's a patented idea or design, how do we protect it? How do we make sure that nobody steals our idea? You know, it's funny. I was just talking to a class recently, and I was talking about how often I do these courses around strategic development, strategic execution, and there's usually a point where somebody will tell me, I have this really great business idea, but I don't want to share it because I don't want anyone to steal it. And then, of course, I've never heard of these ideas or these people years later, but they've always got some like really great idea that they're afraid to share. And one of the things I always say is don't be afraid to share your ideas. Like there are things that we need to protect. There are things that we need to share and put out there. And, you know, maybe we can protect them later as they get further developed. I'm really excited today to talk to our guest because they come to us with 25 years of experience in the area of being a patent. They are a patent attorney who has helped secure over 700 U.S. patents and previously worked at the USPTO, the United States Patent Examiner, as a United States Patent Examiner. They've also led U.S. nanotechnology patent prosecution for a Forbes World 100 company. And so they understand a lot about intellectual property and how those things work. So I'd like to welcome to the show, Mr. Austin Bonderer. Austin, how are you?
I'm doing great, Ben. Thanks for having me on.
Thank you. So I kind of teed this up because I will say, in the business consulting that I've done, in working with students around businesses, this topic is one of the things that comes up a lot because I think it's one of the things that people hear about. The government's involved. People get a little nervous about that. You know, we file these things, we put it in, it seems like a black hole. It goes off somewhere, and then weeks or months later, you hear whether or not it's a yay or a nay. And it just seems like a lot of work and a lot of gyrations to ultimately get to an answer. So I'm hoping that we can get into, you know, patents and IP and all of that stuff that you've done. One of the things I like to start off with, though, is to kind of get a little bit of background on the person. So if you wouldn't mind, share with us a little bit about yourself and kind of what you've been doing up until this point.
Well, basically, so my background, the story I usually tell is like how I got into patents because it's kind of one of these things. My generation, people kind of fell into becoming into patents. It wasn't something that most people started off saying, "Hey, I want to be a patent attorney." But I must say that my DMs are full of young people saying, "Hey, I'm going to school. I want to be a patent attorney." So things are a little different. I started off basically. What happened was I grew up in southern Mississippi, and my dad's house almost caught on fire. And it was in the summertime. So I, being the young one, I was the one who got to go up in the attic and wire his smoke detection system. I mean, he helped me obviously, but I was the one who had to run the wires. So that being said, I always remember how horrible that was, and there had to be better, things to make this work. And then when I went to school for engineering, my thesis was, and this is right when those wireless doorbells first came out. So I thought to myself, look, there has to be better way and all stuff. So I actually designed and put together two smoke detectors that would respond to smoke, but they would also send out a wireless signal that would kick the next one off. And then the idea would be that you have a mesh system. So this was actually my thesis back in 1999. I actually believe I beat Kitty, who eventually came out with this system. So I too started something, didn't pursue it, and then, man, I came up with that idea many years before they did. But guess what? They made all the money. But in any case, it set me on my path. after coming out of school, I wanted to work at the University of Virginia's patent transfer. It, University of Virginia's patent transfer system or their technology transfer system. You're like, because who doesn't want to live on a college campus for the rest of their life? It's like a beautiful place. It's like la la land. But they're like, young man, you don't have anything for us. Go out in the world and maybe you can come back. Just so happened the patent office was hiring people. I went to school for engineering. I literally thought I was going to work in constructions and that kind of stuff. But right as rain, I went over to the patent office, started working in a closet, basically, researching, examining patents, and then it went to night school, ended up becoming a patent attorney, and then I left the patent office and started working on the other side.
That's crazy. So, we're talking the dawn of the computer era probably didn't have the databases wired up that we do today. So I would imagine patent research was a little arduous at the time.
Well, I mean, let's be honest. No, yes, when I was at the patent office, they still had the stacks of shoes. They called them shoes. They were basically like little boxes with the paper patents in there. And that's pretty much all we researched. And it's very difficult. And even now, patent examiners truly, really stick to patent applications and previous uh, issued patents when they do their searches. Every now and then they'll probably go outside, but the majority of it's still whatever the database is of the patents and previous applications that are sitting at the patent office. But understand, we look around and, stats lie or whatever. When I was working in the patent office, they always said only 5% of all these patents ever make it to market. So while we look around and we see tons of stuff, in reality, there's a lot more technology disclosed at the patent office in the form of prior patent applications than patents.
It's to me, I've always found it fascinating. As a matter of fact, funny enough, I was just having a conversation with my wife about this the other day because we were talking about how, on TV they have those commercials about like, you have an idea, like we can help you patent it. And I always feel like, no offense to those companies. I personally have never used them. So I'm probably saying this a little ahead of some intimate knowledge, but I always feel like they're a little bit of, I don't want to say a scam because they're a legitimate business, but they lure people in who just are uncomfortable about filling out paperwork and that they're really not doing anything more than you could do on your own if you just went online and put in a little homework and figured out how to file your own patent. So I'm curious, do companies like that in your experience with this, and I don't know if you have any direct experience working or knowledge of those companies, do they really do anything more than what a person can do on their own?
Well, that's a loaded question, and I don't want to talk ill, but I've heard some horror stories of people who've left those companies and found a patent attorney. Now, to be honest, my job is writing patent applications, so I, prefer you'd write a patent application. But if I find that I don't think it's in your best interest, I'm going to tell you.
No,
These
that's good. I'm sorry. Go ahead.
No, and then understand, my understanding of these companies, a lot of it is they take a percentage of your patent ownership, but you're still paying them for all this stuff. Like they're like, well, we need to make brochures of your idea. We need to do all, I mean, it's all this stuff outside the patent, but they're also selling you the patent services. And then they're like, well, we have contacts with, hundreds of manufacturers and companies. That could be junk mail. They could literally just be sending your packet in with a bunch of other stuff, goes in the mail, gets these companies, they could just toss it. I don't know what their contacts are. But say your patent makes it, say it's a great idea and it actually gets through, they get 10%. So they're making money either way, as far as I understand. If you feel so, what I tell people, if you feel like you're the product that's being sold, you are.
Yeah, and I guess too, and I thank you for putting that out there because I do want to make sure that I articulate this correctly. I'm not saying that everybody should bypass seeking advice on patents because I think there's certainly some things you have to be aware of to make sure that you are protecting. But I think sometimes it does help for people to dig into the process to understand what needs to be done. Um, Whether you're trying to and help me out with this, if when we talk about USPTO, what did you cover? Both patents, trademarks? Is there a limit to what you do, or do you just strictly focus on patents?
Well, we don't like when you work at the patent office, you're either a trademark examining attorney or a patent examiner or a primary examiner. It's like different levels of examiners. But when you're an examiner, you're generally put in a very specific art unit. So understand there's actually like 8,500 patent examiners. And
Okay.
each one is supposed to be, pretty much their entire careers are spent in one area. And so when you get up to expert level, which is the highest level of patent examiner, and I remember working with these guys and come in like, man, I can't find this thing. And they'd be like, well, you go look through these numbers. So they would know that it would be between, patents, 9 million in this and 9 million in that. And they'd be like, go look in there in this area and you'll find it. It was just amazing. And back when we had the physical shoes, they could literally just point to the box and say it's in there. Hmm.
That's great. And that's just years of experience, I take it.
Yeah, in the area. So they knew those boxes better than anything. But, obviously the office moved to a more electronic, and that makes it a little different because for me, I started getting spatial recognition. If I'd go into this, what we call the shoes, you go in there and you'd be like, it's in one of those boxes because when you do it every single day for, years on end, you start to remember where things are. Now, examiners will also find pieces, old patents or pieces of prior art they feel like teaches so much of their art. They literally just keep it on hand because it can serve as the basis of a rejection on a large number of applications. So, this is kind of the institutional knowledge that they obtain after years of working at the office.
So you yourself, you kind of focused in this area of intellectual property. And I imagine, given the number of patents that you've worked with, you've got a lot of experience in reviewing them. When you think about entrepreneurs today or founders who are looking to patent their IP, what are some of the common things that you see that they either miss or misunderstand?
Well, I mean, there's different types of IP. So you talk about trademarks and then you talk about patents. Now, generally with patents, one of the big problems is disclosure. And I understand, like you said before, you need to let someone know. But some people get so excited about their new idea, they just, blurt it out to everyone on the internet. They show it on Facebook, because you solved a problem. You're proud of it. You're proud of yourself. It's probably one of the coolest things that you've ever come up with. And a lot of times, I equate it to like a new baby. They're like, oh, look at my baby. Look at everyone. Look how cool I'm proud of my baby. Don't show people your baby. Keep your patent, your inventions, tightly within yourself. And if you have to tell someone, call a patent attorney, and they'll listen to you, and you can let it all out, and you feel like you've told someone about it. And then at least that way, you might start the process of protecting this with a patent because disclosure kills patent.
Interesting. So earlier I was saying, well, I have to correct myself because earlier I was saying, hey, go ahead and share it with some people. And you're like, no, don't do that.
Well, share it with the right people. I mean, that's the thing. Like, you get it protected. If you actually think you have an invention and you think it's something you're going to build a business around, it's worth investigating whether or not it should be or can be protected by a patent. Once that happens, I mean, obviously go out there and try to make money off of it because at the end of the day, the only reason why you're spending money on a patent application is to make money off something. So
Yeah, that
you
makes.
will have to disclose at some point.
Do you, being in the space that you are, do you find that patent attorneys will often hear you out? But I think sometimes one of the things that holds people back is, well, if I contact an attorney, they're going to charge me a bunch of money, right
They,
away.
they can, I offer free consultations. We basically go through the process and the costs involved, and kind of that the base knowledge of what you know you're getting into and the expenses involved. Um, but generally, so I try not to have confidential information exchange until we uh, we have a fee agreement in place and we're actually attorney client. Now, it's kind of one of those things that unless I have personal knowledge of something, I can't tell you if you have a patentable invention or not. So basically, our first step is when you come on board, we order a prior art search by a search firm, and then we analyze those results in view of your idea to see if it's likely to be rejected by the patent office.
So let me ask you this, and kind of in this space of having an idea, because I think about the Aaron Sorkin movie about Facebook, and one of the things that they talked about in that movie is having the idea for Facebook versus actually building it and making it work. And the Winklevoss, what wait, Winkel?
The
I
twins,
know
right?
I'm saying
Right.
their name incorrectly, but Winklevoss twins, that's what it was.
Yeah.
Uh so they ended up suing Mark Zuckerberg because they said we had the idea for it, and then his counter argument was, "Well, I'm the one who actually built it and put it out there." Um, when does when does that idea become something that somebody can claim as their intellectual property, and at what point does it need to be protected to kind of maybe avoid things like what happened in that case?
Well, just to be clear, software patents have pretty much been decimated since the Alice decision. But I know what you're saying in terms of like, when do you move forward with a patent? Well, that's why you need to have a good relationship. If you're in this business or in development and all stuff, you need to have a good relationship with the patent attorney. So you can just call them up and be like, hey, this is kind of our thought, and the attorney might say, hey, you need to flesh that idea out a little bit more. But at the end of the day, it's reduced to practice when you put it on a piece of paper and you can teach one of skill in the art to make and use the invention. Now, people do ask me and they're like, hey, I got this idea for an electrical device, but I don't know anything about electronics. I don't know how to wire anything or do anything like that. I'm like, don't worry about it. Because as long as someone of skill could make it, then it's enough of an idea that we can actually get a patent on
So you don't have to have the
it.
technical expertise. You just have to have the idea, and I would imagine awareness of how it would actually work and function, right?
Correct. I mean, to a degree. I mean, let's take you don't have to be able to build a microphone to say my invention includes a microphone. Like you don't have to go into the dynamics of the diaphragm, the electrical sensors, the magnetics, and all that stuff. You just can say a microphone. As long as someone of skill in the art can make it, there you go. So that's kind of, and as long as it works, I mean, so you can invalidate a patent after it's issued, or you can get rejected if it's not enabled. Like you keep one of skill in the art can't make or use it, and then the other one is that it really doesn't work. So the patent examiner can actually challenge you and say, "Hey, what you're saying here makes no sense whatsoever. You're not going to get a patent on it because there's no way this thing works." And then you can prove that it does work, and that's very rare. Um, the way the patent office works is you used to be say you had to reduce it to practice, but if you put it on a piece of paper, write the description, show the drawings, it's considered constructive reduction of practice. And when I used to be there, there were only two things that ever required an inventor actually prove to us that it worked. And one was machines that affect the weather and perpetual motion machines, because they just did. They probably got a bunch of patent applications for that, and they were like, it probably doesn't work.
So if you are, let's say you're a business, you have some IP, you think you have some IP, and you want to go out and you want to raise money. You want to talk to investors about this idea. What you're saying is talk to a patent attorney first before you go out there and try and raise money on an idea. to find out what probably find out whether or not it's patentable or not. But definitely to make sure you're not over disclosing information to people.
Right, but you can also, disclose only as much as you need to. Try to have NDAs in place. But also, when you have an NDA, you need to make sure that there's a quid pro quo in there. A lot of people have come up to me and said, "Hey, well, I told my buddy, but he's under an NDA." And I'm like, "Well, what was the consideration?" Well, he promised me he would just keep not telling anybody by signing this paper. I'm like, "No, that's not a binding contract. That's a promise." So, in order to have a binding contract, you have to have something for something. Generally, you give me something and I pay you for it, right? That's my pay versus the item that you gave me, right? So, when you're doing NDAs and you're just kind of doing them on your own, you're like, "Hey, I had this guy sign it." You need to make sure that they're getting something of value for agreeing to keep this quiet. Now, when you're dealing with investors or companies, a lot of time the consideration is, "Hey, we might go into business later." And that's a worthy consideration. I promise to tell you my secret in order that we possibly might go into business together. That's a good enough quid pro quo. But if you're just telling your buddy and having them sign an NDA and there's none of that quid pro quo, that's not a binding NDA.
Good to know. Good to know. Well, so let me ask you this because you've been doing this for quite a while. You've seen a lot of different patents in your time, I'm sure. Are there any that kind of stand out as great examples of people who had everything and kind of teed up and in the right way? And I do I don't know. I'm thinking about this in the terms of like consumer product goods because that's kind of my background. Like,
Right.
is there anything that stands out as here's a good way to do it versus where we might run into some trouble?
Well, I mean, it's kind of one of those things. There's an old thing in the law is like when you have facts, argue the facts. When you have the law, argue the law. And when you have neither, bang the table. So when someone comes to me with a really good patent idea, it, they're always like, "What's your success rate?" And I'm like, "Well, it depends upon the patent because if you have a really good idea, it's going to get through. Like that's just the way that goes." But I do think I'm very good at arguing and getting things passed that might be a little rocky. I actually believe that's where I specialize, or where my talent lies in this process. But you've probably seen this a million times. Then great product, great idea. They can't get it to market. They don't have the knowledge or the fortitude to stick it out to get it to market to make money off of it. Because I can tell you, I've seen some wonderful ideas come across my desk, and then it's like it just dies on the vine. Whereas I've
Yeah,
seen some, and I'm like, yeah, sorry.
no, no, no. What you said there, yeah. I mean, I can think of one product. I worked with small business one time. Great invention. So what it was is kind of cool. Is it was a device called the Tostia, and I had a podcast a little while ago, so people are probably familiar with the founders because we used to do a couple episodes with them. But Tostia was really interesting. So what it was a grill, literally like a collapsible grill that you can insert in your toaster. And the whole idea around it was that you could like take tortillas, you can fill them with, cheese, meat, filling, whatever. You fold it up, you put it in a thing, and you toast it in the toaster. And they had kind of, I believe they had a design patent on the idea. I thought it was great. I thought it was a really cool, innovative little thing. Unfortunately, just didn't get the kind of commercial traction I think it deserved. And they tried a couple different ways to get it out there to get it to market, but unfortunately, to your point, just the patent is one thing, but then it's sales, it's marketing, it's manufacturing, it's they're getting molds made in China to get these things built, and the shipping costs and everything that it takes to just bring it to market. There's just a lot more to it. So yeah, to your point, patent is one step, but then there's so many other things that are part of it.
Yeah, and so what I explained to independent inventors and stuff like that is like, look, If you don't have a business plan to monetize this, we're just buying you a very expensive piece of paper. And, and so I say you need a business plan to get this to market. And getting a patent is not easy, but it's the easiest part of this process. So you got a long road to hoe. And if you don't want to do it, let's not invest in this patent. So that's kind of one of the first things I explain. And also another thing is a lot of independent inventors and stuff like that think, that old fable, if you build a better mousetrap, the world will beat a path to your door. It's not that easy. The business plan of, hey, I'm going to get this patent and then I'm going to go up to the big five manufacturers in this area and say, hey, look at my idea, pay me for it. It sometimes happens. It just doesn't happen as nearly as often people believe it does. So I tell them, don't count on that. That's a great thing if it happens because you want mail money. But in order to truly make money on most patentable inventions, you have to bring it to market, show its marketability, and then you hope that you get bought by those big five manufacturers.
And that's not if they haven't made some iterative, design or approach to it themselves. They haven't created some other kind of alternative approach that doesn't violate your patent, but allows them to patent their own idea.
Right. You gave them the idea. So that's why, and another thing I try to explain to inventors is don't think of the protection that a patent gives you as like a wall. It's more like a minefield. And people can get through minefields. It's just how hard, difficult, how many mines are there. So it's something that we try to work on is we try to give you the best coverage possible, but we're also looking into a crystal ball. We don't know where the enemy's coming from. And so, when companies are actually, bringing things to market, because it takes 2 to 3 years before the patent ever even gets looked at. So generally, we have an idea of where you're going with this idea when we start arguing with the patent office. And then when it issues or it's about to issue, we have this conversation about continuation practice. And the reason why, I tell companies, it's kind of like insurance. Because if you're spending all this time bringing this to market and you're basing it on this patent application and this patent, it has a limited number of claims and it has certain protection. But if you do continuation practice, you're able to keep that patent family alive. And what I mean by that is you're able to draft new claims as long as it falls inside the original scope of the disclosure. And trust me, if you know where your knockoff competitor is coming from, I'm not saying that we can always write claims that would catch them, but it's much easier to try and draft claims that would catch them because when that issues, then we can go to that knockoff competitor and say, hey, you're infringing our new patent.
Well, and to that point, you talk about knockoff competitors. It's a little bit easier within our boundaries in the US to protect those things. But as I was explaining a moment ago, my friend who designed Tostia and got sent those molds out to China to be made. China has a different approach to IP than the US does. I don't think that's any surprise by anybody. But one of the things that they tend to do is be inspired by other people's designs and replicate them on their own.
Yeah.
So to what extent can we protect those things that we've patented here stateside?
Right. So, I mean, if you have the US patent, you can, go to the Federal Trade Commission, you can get bans on imports, these kind of things. You can enforce your patent in the United States. But, this goes to the other point of, you know, Asia countries tend not to have as robust of a patent system as the United States does, but they're getting better because they're starting to see the value in maintaining patent rights. When I would travel to China for work sometimes, and my understanding is that some of the fastest growing segment of millionaires in China at the time were new patent attorneys because they were suing people now and winning. So my suggestion is always, look, if you can't do patents all over the world like pharmaceutical companies do, because they have all the money to do it. think about where your competitors and you are actually going to do manufacturing. And if it's China, then let's apply for a patent application in China. We've already written the application. It doesn't cost nearly as much to file in China as it does the United States. Therefore, let's just go and put it in there and see what we get. And you might have protection. And if you know that your a factory over there is infringing your patent, you can try and enforce it there because all patents are local.
Yeah, so one of the things I think about, I worked for 20 years at Coca-Cola, and what was always interesting about that experience was the fact that Coca-Cola has a secret formula. They've never patented the formula for Coca-Cola because in doing so, they would have to reveal what's in it, and they not done that. It's very interesting long history that Coca-Cola has had relative to their product. But the one thing they're very fierce about are their trademarks, right? So they will fight you all day long about violating their trademarks and the logo. They've even got a Pantone color called Coca-Cola Red. Like that is the color they use for the company. But for those entrepreneurs that are out there, and maybe I think about this a little bit more in the food space. Like, when is it best to have a patent versus a trademark versus to just keep it a trade secret?
Well, you can't really get a patent on a food product generally. I mean, it's got to be inventive, and most food's
Not
been
even
out there.
Beyond Burger, the fake meat.
Well, that's a new that's not that's a new material, I would say, or whatever you want to call it. But yes, they can get a patent on possibly. I don't even think. I mean, if it's just maybe it's the processes by which they're using, but unless items are great, but the mere recipe probably not, unless they have a patented product that goes in it, because generally, like I get a lot of calls about supplements. Hey, I have this new supplement. I want a patent. And it's what I tell them is, you know, if you get a multivitamin and the vitamin A does what it's supposed to do, and vitamin B does what it's supposed to do, and vitamin C does what it's supposed to do, you're not going to get a patent on that because it's merely the same as if you took A, B, and C by themselves, right?
Yeah, you, you
Unless you
you can't patent water and flour, and say I have a new bread.
Yeah, exactly. So, but if you were able to prove that you came up with, you discovered, take milk and has vitamin K in it, right? It's supposed to help with calcium as well. If you found that some new combination of old products rendered them greater than the sum of their parts, you could get a patent on that.
Interesting. Yeah, because a lot of drug companies tend to do that, where they bring in new combinations of things and then are able to patent those newer ingredients. I think of things like,
Right.
well, I don't know, maybe it's probably not a
It's not
patent,
even,
but
it's typically the same ingredient. I think what you're thinking about is take like Proscar and Propecia. Or that one was a prostate drug, and then what they found was people were growing hair, so then they patent the use of this product to grow hair.
yeah,
Botox started off for people who sweat too much, and then they realized that it did wrinkles, so then they patented the use of Botox to treat wrinkles.
right,
So
right.
that's how they're able to extend kind of the patent coverage of their products, but the actual product might be in the public domain. In fact, Supreme Court just heard arguments on this thing called skinny labels. Now, understand, I don't do chemistry, I don't do pharmaceutical, but it's a very interesting case because to think of it this way, you have a product, it had a patent, it expired, that product is now in the public domain. But during the use of that product, someone found that it could be used to treat a certain disease. So they have another 20 years on top of that. So this one's now in the public domain, but that use to treat that disease is still covered. So these generic companies are coming out there and saying, well, we're making the product, but on our label, we're not describing this use that's patented. Everything else it can be used for, but not the patented method of treating something, a specific thing. So even though the doctors may know, hey, there's a generic version that does the exact same thing that this other one does, the label that the generic companies are using can't say that they are it can be used to treat that patented method.
Yeah, I feel like there's a lot of that going on with like GLPs, for example, because they're finding new applications to it, new kind of benefits to it, and they're saying, well, it's kind of the same thing. I don't know. I'm not a doctor. I don't want to
Right.
I don't want to put bad information out there, but what I'm
Mm.
hearing is that yeah, people are doing that often, and to your point, as a means of kind of extending the life of the patent to kind of keep a lock on those things. I mean, in that industry, those products are very expensive to develop. So I would imagine they try very hard to get all they can out of what they've developed there.
Right. I mean, that's the go back, and I truly see the benefit of patent coverage and even the new use. I mean, we're really talking about 20 years from the date of filing. I know that sounds like a long time, and when you have a breakout drug, I mean, you could save a lot of lives. But if you don't give people that financial incentive, they're not going to go out and find a new cure for things. So it's a necessary, I'm not calling it evil, but it's the payout that you get for spending all the money and the time, you know, devoting your life to this stuff. And if you find the answer, within 20 years, anyone can use it for that purpose.
Yeah, no, that's very true. It's uh, again hundreds of millions of dollars poured into the development of those things. And I understand the argument against, but at the same time, there's also, let's not also ignore the benefits that come out of it as well.
Right.
When, because we're in this era now, it's talked about so often, AI, it's infiltrating everything. And when you were referencing these boxes of material, databases, logs of data. One of the things that you mentioned was the length of time that it takes to bring a patent to fruition. You kind of dropped in there. It's about 2 years. Do you see AI closing that timeline, or because why is it so long?
Well, I don't know how. I assume they're working on that at the patent office. I mean, because generally when you file, it's 2 to 3 years before they even look at it, and sometimes it can be more than 3 years. And believe it or not, this is actually better than it used to be.
Oh my gosh.
Yeah. So I mean, I think I just had a patent issue that was filed probably 4 or 5 years ago, and there really wasn't a lot of back and forth with the examiner over it. There was one office actually sent it in, and they allowed it. So that actually had an extra 1,000+ days added to its term. So while we say 20 years from the date of filing is the coverage of your patent, if the patent office is so slow, they actually add time to the end of it. So I don't know if that answered the question you're
Well, yeah, I
posing,
mean,
but yeah.
I still go back to the why does it take so long? Like, is there, I mean,
Oh,
it's like I'm thinking of the movie Zootopia and going to the DMV and the sloth just like
yeah.
working there. So it's like, I know folks are doing their best. Like, is it because there's just so many? Is it because there's a process to it that is just takes an ungodly amount of time? Like,
Well,
why so long?
it takes a long time to probably get an examiner up to a speed. It takes years to get them up to speed, probably where they start paying back. I guess I don't know how you'd explain that, but when you work at the patent office, you have a quota system, and every step as you get promoted in the GS system, they expect more work out of you because you're supposed to be more proficient. So that being said, and there's
Not
80.
efficient, proficient.
Yeah, proficient. So, but the issue is just more. You have 8,500 plus patent examiners already, and they have to put work out constantly. But it's hard to move where technology might move super fast. I remember for a while there, I was working in business methods, and that was all the .com boom. And those things were like 5 or 6 years old because they just got hit. And every time you send a response, they're like, they were belly up already, right? I remember one was like some kind of selling shoes on the internet. That was the thing. And this thing had totally, if it was ever a startup, it clearly had folded by the time the patent office ever got to it. But that's not an issue anymore because we can't patent software. Most software. There's obviously exceptions to every little rule, but
Yeah, I remember back during the .com boom, it seemed like everybody. Yeah, so maybe that's what created the backlog.
well, it's just technology moves, and then it's hard to get these people trained because they spent you know years, 20 years, developing these skill sets in that particular area, and that area may dry up. You know what I mean? Like there might not be that movement in technology anymore, but they flooded the space 20 years ago because that's where everyone was going. So it's
Yeah.
hard for it to just get these people trained up in the new areas and the things they try to, but some things just aren't cutting edge that were back in the day. It's just it's not pushing that way anymore. So now it's a boat, you gotta turn it. So
I mean, on one hand, and again, I'm completely outside looking in here. So, my pragmatic analysis here is only because I'm so ill-informed on the internal workings of this stuff. But I'm like, if Palantir can find fraud across the U.S. government, can't they help the patent office just get caught up?
I don't know. If I had to guess, there is initiatives inside the USPTO to how to use AI to supplement examination.
Yeah,
But there's a
I would
big
I
thing.
would
But
imagine there's got to be something.
oh yeah, I mean they were always trying to automate things. I mean they're always trying to make us move faster. Well, when I was there, they wanted more productivity. The issue, I think, part of it is that at least for now, one of the big issues of getting a patent is take mechanical items. And when you look at it, some people might call it a screw, some people might call it a fastener, some people might call it, some other term because, patent attorneys are always looking for the generic term to try to give the broadest scope possible. But there can be 100 different words used to describe the exact same thing.
Yeah.
So this is where you need that kind of visual, hey, that kind of looks like it, uh, analysis. And then another thing is it's like there are two hurdles really to get in a patent. One is novelty. Novelty means is that the exact same thing has not been disclosed before. And the harder one is obviously, and that's a judgment call because it's kind of like saying if you have a patent that's A plus B plus C, and the examiner finds a piece of prior art that has A plus B disclosed, and then they find another piece of prior art that has C. If they can make the argument that it would have been obvious to add C to A plus B to arrive at your invention, you're not going to get a patent. And I would
Interesting.
say most of my back and forth with examiners is based upon that standard. What is obvious to you is not obvious to me. There are some legal standards, but you have to argue why this isn't really obvious.
So let me ask you this because yeah, I'm a big sci-fi nut, and something I think about is there's this, for those who follow sci-fi movies, we're talking about deep space, right? So there's this point in a movie sometimes where we send out a message, right? But it's going to take 3 days for it to arrive, and then they hear it, and it's going to take 3 days for it to come back, right? So there's a big gap of time. When you talk about going back and forth with the USPTO, like is it kind of like that where it's like they send a response after 6 months and then you send a response and then it's going to take them 6 months to get that response and review it? Is uh, Please tell me that's
A
not
little
how
bit.
it happens.
No, I mean, they get it, but they just have backlogs. So not only they're examining new applications, they're working on your application. So they have typically, uh, I think it's 2 months to respond. So we have 3 months to respond without paying any fees. You can go up to 6 months with additional fees, and it can get pretty expensive. But you reply, and then generally within 2 months they will apply to you. Now, I have a case right now where I send it in, and the examiner hasn't responded in, I don't know, 6 months, 7 months, and I'm
Yeah.
sure it's sitting on his docket, and his supervisor's like saying, "Hey, you need to get this off our document," because the supervisor gets dinged. All their bonuses are basically tied to certain metrics about moving things along. But there's a weird little thing at the patent office. Even though they're called a supervisory patent examiner, they have no real control over a primary examiner and what they choose to do.
Hmm.
So you can be like, "Hey, supervisor, I need examiner XYZ to do something," and they need to do something, and it's clearly their responsibility to do something. And they're like, "Hey, man, my hands are tied." So they
Interesting.
have no
I guess
real
though
power.
that independence does help in some situations, even though it can be a little frustrating. I'm sure there is probably that impartiality does help.
You know, I assume that's the way it was designed, but I have never, in my 5 years there, and I'm not saying it never ever happened, but I never saw any pressure to be like, allow this. Might have been like,
Yeah.
do what you're going to do, or I've seen pressure saying, as a supervisor, I believe there's something out there. Go search more and go find it. So you don't allow a bad patent, but I've never seen anybody come in and say, "Hey, you need to allow this patent."
Yeah, I mean that would make sense because it's kind of like putting the foreman in charge of quality inspections, right? If
Mhm.
they're getting incentivized for the amount
But
of production they put out, they might, not necessarily look at quality as much, and
well,
that then introduces issues.
well, once you become a primary examiner, and it's generally after 5.5 years of being there, and you go under a thing called the program, where they scrutinize your work with a fine tooth comb, whatever, and then you become a primary examiner. At that point, we always said you're your own patent office. And generally, when you get to a certain level, even if you're a junior examiner, you're kind of your own patent office too, because your primaries or whoever's signing off on your work trust you for doing your work.
I have to say, in this conversation, it reinforces in my mind why you should work with a patent attorney, primarily because you could fill sure you could go fill out all this stuff online yourself. You could. There's nothing stopping you. But you're probably going to miss something. And it's probably better to have somebody who has some experience at this because, if for nothing else, the amount of time that it takes, I mean, why turn something that could be as short as 2 years into something as long as five or more because you keep missing something?
Well, I think the
This is
big issue is that, understand once a patent is filed, it is set in stone. There's no correcting it. So, I've had people come up to me, after like, "Hey, they filed what they call pro se. That means by yourself or, as I forgot what the Latin meaning is. But anyway, per se." And then they come out and they're like, "Well, the examiner just tore apart my thing saying, my application, I'm missing this. This isn't there. This needs to be fixed." And you're almost at a point where you can't really fix it because every time you add something, the patent examiner is always going to be like, "That's new matter." And new matter is a death knell. You cannot put it in there. And it makes total sense because think about that. After 2 years, you're like, "Oh, I improved my invention a little bit. I'm just going to put that in there." That it can't work that way. It's once it's filed, everything in there, it's set in stone, and that is what you're dealing
so it's just better to start new.
with. Well, then you're at the problem of you probably already disclosed it. So now everything you did before is prior art against what you did. So the United States is kind of cool in the fact it's the only place I'm really aware of that gives you a year from your first public disclosure to filing a patent application. First public disclosure or sale, whatever occurred first, within a year of that, you better have filed your patent application. If you hadn't, then it's prior art. But say that you have a fatally flawed patent application, you filed it, and it takes 3 years. So you've been doing this stuff for 2.5 years over here publicly. if this is fatally flawed, you can't come back here. All this activity over here is now prior art to prevent anything from you filing something new.
So, I got to ask this because in the back of my head, I just wonder, just again, because we're talking about things that take a little bit of time, take so long to do. And again, I'm kind of teasing here. I'm joking when I ask this, but have you ever called a client back and been like, hey, we got that patent? And they're like, oh, yeah, I forgot we did that.
Well, not really. I guess the closest thing to be to that is when we were able to get software patents. And software is different than mechanics and structural things. I mean, when you retool a line, that's expensive. When you redo molds, it's expensive. But software people are just like, enter, boom, totally changed the way everything worked, right? So, and especially it took a long time to get software patents. So it would take us about 5 years to get them. And I'd be like, hey, I got you a patent. They'd be like, man, thank you very much. But we stopped doing that 3 years ago.
Wow, I would imagine back in the day when, especially just after that .com era, that there was probably a lot of as I'm explaining this, I'm thinking back to those wars between Microsoft, Apple, Google, everybody just kind of fighting each other over, we took
Yeah.
this bit of IP and incorporated here, and you
And
didn't
then
get a
you took
license
this
for it.
part. Yeah. Yeah, exactly. So basically at the time, the .com, there's a couple of things here. Large corporations generally will build. Part of the reason why they patent so much stuff is, when you're just building and doing so much stuff, you're bound to infringe somebody. And it's like those big, like Apple and Samsung, they were going after each other because Apple
Yeah.
sued Samsung. And as soon as that happened, Samsung probably looked in their patent portfolio and found like 15 things that Apple was doing and saying, you're infringing that. So you guys want to go to, DEFCON 3 over this stuff? We can. So a huge patent portfolio can actually act as a shield from getting sued, you know, for certain things because, hey, you want to pick a fight with me? I got a whole bunch of ammo over here too. So, but I think the one that I always remember from the .com, do you remember BlackBerry?
Yeah.
Remember how they ended?
Well, I know that smartphones kind of put a nail in their
Uh,
coffin.
well, they
I'm
got
trying to
nailed
think.
because what happened was .com boom, and there were companies out there that just bought up the IP. So they were
Yes.
like these IP vultures, and they were just holding companies. And then they found that RIM, I think RIM was the name of the company that had BlackBerry. They
Yep.
found a patent they were infringing, and they were just nailing infringing. And it was the basis core of their business. Of course, it was software at the time, right? And they lost. And I think it was like $750 million at the time. This was in the 2000s. I mean, yeah, 2000s. And it killed the company.
Yeah, I do remember that. I think, if I'm not mistaken, they might be making televisions now. I think,
Hey,
I
man, you
think
got to
that's what
pivot. You got to pivot. That's
I think that's what they're doing. But
uh,
famously, a couple years back, speaking of these IP vultures, there was a company out of Texas that had bought some IP around podcasting,
mhm.
and they went after like all the big people in podcasting at the time, like Adam Carolla. They went after Leo Laporte and his company that he has. He does a lot of technology podcasts, and a lot of them, pulled together. They fought it. They actually won.
Yep.
So, but these folks were like poised to basically uh, asking for millions of dollars from these podcasters for violating patents. So it is crazy to me that you've got whole companies in place that their whole job is to go find valuable patents that are sitting around and then go stir up trouble for people.
Well, yeah. I mean, and that's the weird part. You kind of think of it, but if patents didn't have, I mean, it's a property right, and
It is.
it's kind of one of those things. If you bought a distressed property somewhere in the middle of, because these things, you never know if these things are going to hit. You buy it out in the middle of nowhere, and then all of a sudden they want to build a nuclear reactor on your property. Whoa, you hit the big time. But you had to own, gobs of property in hopes that that would happen. So, I go back and forth on it. They call them patent trolls. That's kind of the name for it is non-practicing entity who enforces patent rights. But someone spent time and money investing in developing this stuff. They had a property right. They sold it. Someone is now able to enforce it. So I tend to be, I I know what how the feeling of patent trolls, but it's kind of the same guy who gobbles up land all around a city, hoping that something's going to grow out there, and then he
Yeah.
makes, yeah.
There's a lot of things that are a business that aren't always uh, that don't always feel good that they're a
Look,
business,
ants
but they
ants
are.
serve a purpose too, right? Like they have a purpose and they make the system work, even though they're kind of a pain, right? Roaches
Yeah,
too, like you have to have them, even though you don't want them, but they do
sure.
something. Yeah.
Yeah, no, I know. It is one of those things. It's you gotta go take a shower afterwards, but it's
Yeah.
it is what it is.
Yeah.
So let me ask you this as we kind of look to wrapping this up here. I always like to ask people, what is the one thing that is getting you excited about getting up every day and going to work?
Honestly, like, the patent stuff, I've done it for so long. I'm not saying it's secondhand and the inventions are, this. It's seeing the clients of mine that are making it work. The determination, them going out and making it work. And it's like, and the difficulty that they have ahead of them, but they're still making it work. And it's going to pay off for them in the future. And I'm just happy that I can help them with that. So, I do the patent stuff, but I also try to help them with, look, there are business things you need to do at the beginning. Let's, let's clean your room. Sometimes we have to clean your room, like your mom would say. And if you have a nice clean room, your business is going to flourish and you'll thank me later. You hate me now, but you will thank me later. And just seeing them do well and that I could help them do that.
It's funny. I've spent my career on the operations side of business, and I always say it's kind of like the electric company. Nobody thinks about it until it's not there. And I think sometimes when you're doing these operational functions in business, you put people through a lot. I know I do. Feedback I get sometimes professionally from people I work with. It's like, why do you have so many questions? How come you're dragging us into this minutia? How come your explanations for things are so long? Because if we just glaze over this stuff and kind of think fast through it, we're gonna pay the price later on down the road, and you're not gonna like that even more than the little bit of pain we're putting you through right now. I kind of get the feeling that some of the work that you do in helping people get to their patent, because I gotta imagine that there's probably a lot of small business owners you've worked with and entrepreneurs you've worked with. It's like when they have that patent, when they finally get that piece of paper with that seal on it and but something in their name, the amount of pride they must have in that is probably tremendous.
It's a lot. It's a lot. I kind of try to equate it to, is, that old saying, the older I get, the smarter my parents become. And it's kind of like the nagging things that and you probably did too, at the beginning, the nagging stuff when they were young companies starting up, and then they see it in the future because they see the problems that they missed because we made them do this stuff.
Yeah. Yeah, there's been a few projects that I've worked on where later on people have come back and said, I didn't know it at the time, but yeah, now I'm glad we did this.
Yeah. Well, that's why you hire experts. Like you really, they always, say the best leaders, you should have subject matter experts that know more about it than you do. You don't have to know everything. It's best that you know enough to get people who do know their areas. I mean, what is it? The old saying, you need a good doctor, a good lawyer, and a good accountant. Like everyone should have that because you
Yeah.
shouldn't have to know all that stuff. I mean, you don't know what your doctor, what they know, but you need a good one and you trust them. You need the same thing with your business. You need good attorneys that are entwined with your business so that they can see things that, just a simple conversation would be missed.
Yeah, absolutely. Well, Austin, man, I've learned today. I always love it when I get into these conversations and I learn new stuff because I think that's what it's all about. You always got to be on this path of learning. I want to make sure that people know where to find you. So how do people get in touch if they're interested in getting in touch with you to maybe even share an idea they have and figure out whether or not it's patentable?
Well, lucky enough with my strange last name, I believe I'm the only Bonderer patent attorney in the country. So you just look up Bonderer Patents, should get you to my website, and then you can feel free to contact me then. You can also, if you're willing, if you just want to learn some things, I also have a lot of shorts on TikTok and YouTube that you can view, and it'll hopefully explain a lot of the patent process in easy, digestible little 1-minute clips.
Awesome. What's the channel?
I think it's Austin Bonderer patent attorney. I wish I knew better than that.
Well, you know what? We'll make sure it's in the show notes, and
Okay.
so people can link out to it. I will say, I love putting out shorts, and in fact, when we do this podcast, I always create shorts out of it. I'll make sure that we tag you and tag your channel in it. I find that the longer form podcast, I love the people who tune into the podcast, but it's amazing to me the number of people that tune into those like 2 and 3 minute shorts for like the nuggets of information. And then, hopefully down the line, I turn those casual viewers and watchers into podcast fans.
And I think that works. I mean, I've done it myself. I'm scrolling through, seeing some stuff on, Facebook Reels, and I'm like, oh, that's a funny guy. Clearly a podcast. I'm going to, sign up and listen to it. So,
Well, Austin, thank you so much for sharing your wisdom and your insight. We'll make sure that people know where to reach out to you and get in touch with you. Folks, thank you all for checking out this episode of DissedMedia, A Startup Story. I want to remind you all that we are on a path. We are on a pursuit in 2026 to hit 100,000 YouTube subs by the end of the year. As of today, we are actually just about hitting 32,000. Might even be a little over it now. But thank you all for sharing, for liking, for supporting. And like I said, don't just share with your mom, your dad, your friends. Share with your enemies. Those are the folks who are going to take actions on your words, and those are the ones we want to have dropping by the channel. Also, if you're interested, check out my website, benolmos.com. There you will find the very first chapter of my book, 10 Topics to Help Managers, Leaders, and Entrepreneurs Get Better at What You Do. You can get the first chapter absolutely free. So check it out. Thanks for popping by. Appreciate your guys' time, and we'll see you next time. Have a good one. Thanks for listening to DissedMedia, A Startup Story. This podcast was produced and edited by Ben Olmos and is a production of DissedMedia Corporation. If you're interested in learning more about anything you heard on this episode, please reach out to us at podcast@dissedmedia.com. You can also get more information about this and other episodes or information about our guests by checking out dailypitch.news, our business and insights publication focused on helping managers, leaders, and entrepreneurs get better at what they do.